thank you for joining us. My name is Katie Perez, and I'm a Senior Associate here at Scott Legal PC. Today, we're going to spend some time talking about the extraordinary ability visas and the green cards. But just a few things before we get started. Some of you may know that the firm was founded on an E2 visa several years ago. Our founder, Ian Scott, is in the U.S. on an E2 visa and has been on several different visas, including the F1, a TN, a B, and an H1B. Scott Legal PC is a full-service immigration law firm, and we offer immigration services in several different areas, including the E2, E1, TN, L1, family immigration, national interest waivers, EB-5, extraordinary ability visas, and more. We will continue this webinar series doing at least 2 webinars a week on different topics, and at the end of this webinar, we will send out several useful tools. We'll send you a copy of the PowerPoint presentation from today, a link where you can download the guides that go through the visa options in more detail, and also a link where you can sign up for additional webinars. This webinar will be recorded and will be available on YouTube. We'll also send the link for that. We encourage you to subscribe and hit the notification button as we regularly upload immigration videos on a wide variety of topics. We'll also send you a link where you can arrange for a consultation with one of our experienced immigration attorneys if you would like to discuss your case in more detail. If you do have any questions throughout the presentation, please put them in the chat box and we will discuss them at the end of the presentation. So today I will be presenting the first half of the webinar, and my background includes 10 years of adjudications with USCIS, where I did adjudicate the O petitions. We're also joined by another senior associate here from Scott Legal PC. The other senior associate is Jiyae Hwang, and Jiyae Hwang has earned her undergraduate degree from Harvard University, her law degree from New York University School of Law, and she's an amazing resource and has advised many professionals on EB-2 National Interest Waivers, EB-1s, O-1s, and green card matters. So without further ado, we will get started. Okay, so we're going to begin with just discussing the extraordinary ability visa categories. So the first ones we have listed here are the O-1A and the O-1B. Both of these are temporary non-immigrant visas, and the O-1A specifically is for individuals with extraordinary ability in the sciences, education, business, or athletics. The O-1A does have a very high standard in which you do have to be one of a very small percentage who's risen to the top of your field in your profession. We also have the O-1B. Again, this is a temporary non-immigrant visa, but it's for people with extraordinary ability in the arts. So the O-1Bs are treated a little bit differently than the O-1A, and the standard for arts is slightly lower. The person must have received distinction, meaning a high level of achievement evidenced by a degree of skill and recognition substantially above that ordinarily encountered. Within the O-1B visa, you do have another subcategory. This subcategory would be for people who have extraordinary ability in the motion picture and television industry. The standard for the motion picture and television industry is a little bit higher. You would need to show that you do have a record of extraordinary achievement in the motion picture television industry, such that you have a very high level of accomplishment evidenced by a degree of skill and recognition significantly above that ordinarily encountered, to the extent that the person is recognized as outstanding, notable, or leading in the field. So for the motion picture television industry, it would be in relation to peers within the industry is who you're going to compare yourself to. So again, these are the temporary non-immigrant visas, and with these visas, you have the ability to come to the U.S. to work, but your intent is to come here temporarily to fulfill that work. In contrast, we would have the green cards would be for someone who does intend to come to the U.S. to live here permanently. Okay, so we'll talk a little bit about the green card options for those with extraordinary ability. First, we do have the EB-1A. So this is very similar to the requirements for the O-1A and the O-1B, kind of looks like, but there's not that separate category for the arts. So this category is for those with extraordinary ability in the sciences, arts, education, business, or athletics, and it's all under one umbrella of that EB-1A. So the individual must be one of a small percentage who has risen to the very top of your field of endeavor and that you've sustained that national, international claim, and your achievements have been recognized by those in your field of expertise. So importantly, with that EB-1A, the person does need to be coming here to continue to work in that area of extraordinary ability. Um, for example, if you are someone who's had a very successful career and you very well could qualify for that EB-1A, but you just want to come to the U.S. to retire, then that's not going to work for that EB-1A. The government will want to see your statement of proposed intent to see what you plan to do in the U.S., and it does need to show that it's related to your area of extraordinary ability. And so we also have next is the EB-2 National Interest Waiver Green Card. This one's not always lumped in directly with that the extraordinary ability visas, but it can be a good option for maybe someone who was on the O-1, the O-1B and doesn't quite meet that EB-1A standard yet. But you still have this very impressive background and you're working on an endeavor in the U.S. that does have that substantial merit and national importance. So you may be eligible for the EB-2, that second preference visa, if you are a member of the professions holding an advanced degree or its equivalent, um, or you have a bachelor's degree and 5 years of progressive work experience, or you're a person who has exceptional ability. It's important to note that exceptional ability is not the same thing as extraordinary ability, so those are two different things. These basic things are just the threshold requirements. After you do meet the threshold, you do need to then demonstrate that um, you have a proposed endeavor. You need to be able to explain what your endeavor is, and the endeavor needs to be more specific than just a general occupation. So you should offer details to the government, not only as to what the occupation normally involves, but what type of work you propose to do and what you're going to undertake specifically within that occupation. So, for example, if you're coming here to work as an engineer, then you would want to explain that the proposed endeavor should have specific projects and specific goals, what you will do as an engineer. So you do need to provide a very detailed description explaining that proposed endeavor, provide supporting evidence, and then show that your endeavor is of national importance and does have that substantial merit. You do also need to show that you as an individual are well positioned to advance this particular endeavor. So there kind of needs to be a nexus between your expertise and what you're going to be working on. And then based on that, you would show the government or want to show the U.S. government that it's beneficial for them to waive that normal labor certification process that requires a U.S. employer and a labor market test, and that you shouldn't have to go through that because what you're working on is so important. It's beneficial to have you here in the U.S. So one thing to note too that's important with the EB-1A and the EB-2 National Interest Waiver is that you can self-petition. So there is a little bit more flexibility in some ways with these petitions because you don't need to have that U.S. employer, which is not the case for many other green card categories and is not the case for the O-1A or the O-1B. So for those temporary visas, you would either need either a U.S. employer, a U.S. agent, or an agent operating for a foreign employer to petition for you. Okay, so we'll discuss a little bit more detail what's required for each of the visa categories. So for the O-1A, you can show that you have won a major internationally recognized award, something like the Nobel Peace Prize or the Pulitzer, but much more commonly, people are going to qualify on the basis of showing that they meet at least 3 out of the following criteria. 3 is the minimum, but if you have more, you can, of course, provide more to the government. You just want to be able to make sure that you have that sufficient evidence to really develop your profile and your case as a whole. So first we have is the receipt of nationally or internationally recognized prizes or awards. So here, if you're trying to qualify with this element, you would want to consider, was the prize national? Was it the whole nation? Was it international, more than one country? So a prize is typically offered or striven for in a competition or a contest. An award is something that's conferred or bestowed upon you, especially based on merit. So things to consider would be the criteria for winning the prize, the past honorees, the number of prizes or awards given that year, and whether or not there's limitations on the eligible competitors. So you do want to think, were these awards won as a student? Was it something given to you by your university or your college? If so, this might not be very compelling. For these petitions, again, you do want to think strategically about what you're submitting and why. And holistically, you really do want to build your application so that when an officer looks at your petition, they will see like this person is someone who's risen to the top of their field, and they do are eligible for the classification. So just typically things that you've won as a student at a university, um, they may not show that you do have that high caliber, and it can actually start to lower your profile in the eyes of the government officer. Um, I will note in contrast, if you were at a university and you did win a very prestigious prize, where other professionals in the field were also competing with you, um, you may want to include that as part of your evidence because you can show how important the competition was, how competitive and how prestigious maybe this competition was. So next we do have membership in associations in your field which require outstanding achievements. So here you would want a membership that actually does require you to have some outstanding achievement in order to be invited or in order to apply to become a member. It is important to look at what are the requirements for entry. Can anybody enter or does it actually require those outstanding achievements? So factors you might want to consider um, is the membership based on level of education? Is it based on a payment of a fee? Something like the Bar Association for an attorney wouldn't necessarily work because anyone who's passed the bar can join by paying a fee. So it doesn't really require some outstanding achievement in the field to become a member of the bar. Next is published material in professional or major trade publications or major media about you or about the work, something that you're working on. So really, and ideally, this should be some type of article, some type of media publication about you. It can cover a broader topic and include a substantial discussion of your work, but it really does need to mention you in connection to the work. So here the government will focus heavily on whether the article was about you. Next, we have original scientific, scholarly, or business-related contributions of major significance in the field. So an original contribution could include something like patents. It could even be processes, something you've developed for a company. So it is important to show how your work for this requirement has already impacted the field. So a potential impact would not be sufficient for this criteria. And when I was adjudicating cases, often people would come and provide testimonials for this requirement about the applicant's work and how what the potential impact would be, but really this is not sufficient. The testimonials ideally would explain in detail how the work has already impacted the field. Um, Next, we have authorship of scholarly articles in professional journals or major media in the field. So this can include publications in professionally relevant journals, published conference presentations at nationally or internationally recognized conferences. This criteria often applies for those who are involved in academics, but it could apply to other fields as well. We also have high salary. So a high salary or other remuneration for services as evidenced by contracts or other reliable evidence. Again, here you're going to be looking at what is your field of extraordinary ability, what is your occupation, where are you working at, the location, are you earning a high salary in relation to others in your field in that area. You can show this by comparing your salary to labor statistics, but do make sure that you compare what I always say, apples to apples. So if you're going to give the government your hourly wage, then you would want to compare it to hourly wages, not an annual wage. Okay, next is the participation on a panel or individually as a judge of the work of others. So here you must show that you've participated as a judge of the work of others in your same or allied field. An example, this could include reviewing abstracts or papers submitted for presentation at scholarly conferences or serving as a peer reviewer for scholarly publications. So you might want to document your peer review work by submitting a copy of a request from a journal that you reviewed for. You would accompany it by evidence confirming that you actually did complete that review. So typically it could just be, an email from the journal um, back and forth asking for you to review and then demonstrating that you completed that review. Okay, next we have employment in a critical or essential capacity for organizations with a distinguished reputation. So here you would want to explain in detail your role for the organization, in detail how it was critical or essential. Critical is something you could show by demonstrating you've contributed in a way that's of significant importance to this organization or the establishment's activities. Essential would be, was your role integral to the entity? So generally a leadership role within the organization would demonstrate that your role is critical or essential. I think one way to help yourself out if you're trying to explain this element would be really to describe the organization. What's the structure look like? Where are you within this organizational hierarchy? So that would help give the officer a visual of where you're placed and kind of help them easily establish that maybe you have this high up role or your role is critical or essential. You do need to show that the organization is distinguished. So if you are a CEO of a very small company, you could really easily show that your role is critical or essential, but you may have difficulty showing that the company is distinguished. Conversely, if you work for a large company like Apple or Google, that's a well-known distinguished company. It's pretty easy to establish that part of this requirement. But if you're working within for Apple and you're working in the factory, just boxing up those iPhones, you would have difficulty or likely a difficulty showing that your role was essential or critical. So there's kind of two parts to that one requirement. Okay, so next we'll discuss a little bit about the O-1B requirements. So what do you need to demonstrate for the O-1B? So again, this category is for the arts and those in the motion picture television industry. The O-1B does have a similar structure to the O-1A in a sense that you're going to either qualify by one significant national or international award, something like a Grammy or an Emmy, something of a high caliber that can easily demonstrate that you have risen to the top of your field. Or you can demonstrate that you have satisfied 3 out of the following criteria we're going to discuss here in the next couple of slides. So first, something you could try to satisfy would be demonstrating that you have been and will perform as a lead or starring participant in a production or event with a distinguished reputation. So evidence can demonstrate a lead or a lead role by establishing that person has a principal role in the event or production. A starring role would be a position of great prominence relative to others within the production. Generally, the difficulty with this criterion is showing that future element. So it can be really hard to show a future production will have a distinguished reputation in some cases because you may not have those critical reviews or advertisements yet. Next, we have the critical reviews or other published material in professional and major media by or about the beneficiary. So here the difficulty can come with trying to show, the media's major. The government doesn't hold much weight to articles that you can self-publish or are not well known or not vetted. So, if you're self-publishing versus an article in the New York Times, that New York Times article will definitely show that it's, you can easily show that it's major media. So you also need to provide evidence to demonstrate that you or the beneficiary is recognized for achievements that are national or international. Okay, So we also have evidence that the beneficiary or applicant has performed and will perform in a leader starring, or a critical role for organizations or establishments with a distinguished reputation. So here it's important to remember that the critical role is for the organization, not just an event or production like we discussed in that first criterion. So oftentimes as an adjudicator, I would see people conflate these two elements. So they are separate and distinct, and you would need to individually satisfy either one if you're trying to show the government you qualify for this O-1B, satisfying 3 of the requirements. So this one, it is really important to think about, like, maybe you could think about it as, is your role permanent? You know, something within the organization, was it temporary, just an event, you know, might be more fit for the first criterion versus this one. I always gave the example that were you just an actor in a movie? So your role within this was more temporary. It was just an event or a production, or did you work for the movie studio where you did serve as a CEO for the organization, and your role is more permanent? So it is important to think about what was your role within the overall. Okay. So next we do have evidence of record of major commercial or critically acclaimed successes in the performing arts, as shown by box office receipts or record, cassette, compact disc, or video sales. So this criterion does have some outdated evidence requirements on it. So um, for example, no, I don't think anyone really sells cassettes, and very few probably sell those compact discs. So you may have to be a little bit more creative if you're trying to satisfy this element. For example, for maybe to show that commercial success, maybe you don't have those record sales, but you do have a YouTube channel, and on that YouTube channel, you are generating, making money, so that you do have that commercial success. You could show how much money do you earn to the government. You would need to provide an explanation to them and demonstrate why the money you are earning demonstrates you do have that commercial success, but you definitely could make that argument. If you're demonstrating those critically acclaimed success, the evidence should demonstrate that you or the beneficiary's work has received that public-facing praise or positive reviews in the relevant field, such as from professional art or television film critics, something like that. Next is evidence of significant recognition for achievements from organizations, government agencies, or other recognized experts in the field. So this can come in the form of a testimonial, and it should really focus on what is the beneficiary or your achievement. So if you speak to someone's potential, or you mention that they are a hard worker, all these great attributes about the person, that would not be sufficient. So the government really does want you to focus on what were their achievements. Achievements can be interpreted pretty broadly, but you do need to explain what the achievement is and why it is an achievement. So those details on the actual achievement would be really important for that testimonial to meet the plain language. Next is evidence of having commanded a high salary or other significant high remuneration for services in relations to others. Again, you can show this by comparing your salary to labor statistics, just like I explained in the O&A. But again, make sure you're comparing those apples to apples. So if you're providing the yearly wage or the hourly wage, then you would want to provide that comparison in the same manner. So lastly, within the O-1B, for the O-1B with the arts, you do have what is called comparable evidence. So that's to say you're applying for this O-1B in a very kind of odd or niche field, and you feel the above criteria don't apply to you. You would need to explain why they don't apply, and then explain why the evidence you are providing is comparable to the criteria listed in the regulations. To be honest, this is really kind of a big hurdle to meet. And when I was adjudicating cases, I don't think I ever saw someone provide that comparable evidence that was satisfactory to the government. So it is something you can consider. and also try to make that argument if you really do have that niche, different field that you are working in, it may be worth it. Just as a last note, though, the comparable evidence is not available for someone in the motion picture television industry. Okay, so here we do just have a chart quickly to go over what is specifically for the O1A or the O1B. Again, the O1A is for someone in the sciences, education, business, or athletics. The O1B is for those within the arts and motion picture or television industry. The standard for the O1A, again, that one is the higher standard. It's for someone who's risen to their small percentage and they've risen to the very top of their field of endeavor. The arts is for someone who has that high level of achievement as evidenced by a degree of skill and recognition substantially above that normally encountered. And then those for the motion picture television industry, that would be a level of acclaim substantially above that of their peers. So in comparison to the peers. Oops, I'm sorry, scrolled up. How long are they issued for? So the O1A and the O1B can be issued for initial grant of 3 years. You can get an extension for, generally it'd be for 1 if you're trying to continue within the same project, the same employment. If you do have new activities, new employers, new employment, you can extend for another 3 years. You just need to show that you do have the new work that would cover that 3 years. You can also your family can come with you to the U.S. This includes your spouse and any unmarried children that are under 21. So they can attend school here in the U.S. if they come with you. Unfortunately, the spouse does not gain that work authorization by traveling with you. So if your spouse does need to work here in the U.S., they would need to look for some other type of visa category that would work for them. And just quickly with a note for the O1A versus the O1B, because the O1B is a higher standard, if you are in a field that could be considered for the O1B versus the O1A, then it might be a better choice for you to go with the O1B just because it is a little lower standard. It might be easier to obtain that visa for yourself. Okay, so we will go over a little bit now just the extraordinary ability for the EB-1A, which is that green card. So this is very similar to what we discussed in the O1A and the O1B, but some of the language is just a little bit different because it does incorporate the arts, sciences, education, business, and athletics all together again. So the structure is very similar to what we discussed previously with the O1A and the O1B, meaning you can qualify with some type of major award, again, like an Oscar, a Grammy, or a Pulitzer, something of very high caliber would show that you qualify. But most people, again, they do not qualify. They don't have those really prestigious awards. So most people will be qualifying based on showing that they meet at least 3 out of the following 10 criteria listed in the regulations. So these criteria are very similar to what we discussed previously with the O1A and the O1B, but again, they are listed here. I'll quickly just read through them. I'm not going to discuss them in detail because you would meet them the same way you would really meet for the O1A and the O1B. So for the EB-1A, extraordinary ability, you can show you meet 3 out of the following 10. Then you can qualify for that green card. It would be the evidence of receipt of lesser nationally or internationally recognized prizes or awards for excellence, evidence of the membership in associations in the field which demand outstanding achievements for their members, evidence of published material about you in professional or major trade publications or other major media, evidence of your original scientific, scholarly, artistic, athletic, or business-related contributions of major significance in the field, evidence that you've been asked to judge the work of others, either individually or on a panel, evidence of your authorship of scholarly articles in professional or major trade publications or other major media, evidence that your work has been displayed at artistic exhibitions or showcases, evidence of your performance of a leading or critical role in distinguished organizations, evidence that you have commanded a high salary or have other significantly high remuneration in relation to others in the field, and evidence of your commercial successes in the performing arts. Okay, so we are going to switch over to Jiyae now, who will continue discussing the EB-1A green card requirements.
All right, thank you, Katie. Right, so let's go into a little bit more detail about qualifying for the EB-1A green card. So as Katie went over in the previous slide, you may have noticed that the language of the requirements for, meeting 3 out of the 10, they're very similar in language to what's relevant to the O-1A criteria. You either show that you've received a major internationally recognized award, or you can show that you meet 3 out of the 10 at least. Now, the other thing that the government expected petitioners to do is to also show that in the totality of evidence analysis, the evidence would also qualitatively show that you're one of the very few who has risen to the very top of the field. And that two-step Kazarian test was actually what made the EB-1A green card pathway very difficult to be approved for. So let's look over the Kazarian analysis a little bit. Now, one thing to note is that there has been litigation surrounding whether the Kazarian analysis is actually, allowed under the INA. So actually, in 2026, very recently, there was a ruling out of a federal district court in Nebraska that actually the Kazarian test should not really be used. So under the law. So what happened after that was actually that the government didn't appeal that decision, and we're still waiting for any official pronouncement on whether the Kazarian test is officially gone or not, but this definitely gives some sort of a basis to push back if there is a denial on the Kazarian, only the Kazarian step 2. But basically, what is important to note is that under the existing Kazarian approach, there are 2 steps to adjudication. So the first step is technically looking at whether there is any evidence that the applicant provided that meets at least 3 out of the 10 enumerated classifications of evidence that we discussed in the previous slide. So let's say you have one scholarly article that you publish. Let's say you have one judging activity that you've done in an obscure kind of contest. And let's say you have one media article written about you in a nationally recognized, but it's kind of a smaller outlet. So let's say you have that kind of, quality and quantity of evidence is quite low, but technically you meet the 3 the plain language of the 3 criteria among the 10. Now, in the Kazarian framework, right, in addition to meeting the step 1 analysis of whether you have provided at least 3, there would be another holistic analysis looking at the whole body of the evidence and seeing if the whole body, the quality and quantity of the evidence, is something that indicates someone who has risen to the very top of the field. So they would look at things like, when we speak of media articles, not all media articles are the same. A media article in a bit of a smaller niche publication is different from a media article in the Times Magazine. If you're on the cover of Times Magazine, that, certainly has a different strength to, the quality of what it indicates rather than, a smaller media article in a smaller publication. So the 2-step Kazarian test was the prevailing approach, and there hasn't been any explicit change from USCIS saying that this is no longer going to apply, but there has been this litigation that has been going on recently in 2026, so it is worth keeping an eye on whether this will still be the approach going forward. All right. So we'll move on to the next slide. Now, let's shift gears a little bit and talk about the EB-2 NIW green card pathway, which is another alternative classification that you may consider if you feel that your profile is maybe not as, strong enough to qualify for the EB-1A standards to be, one of the very small percentage who has reached the top of the field, or otherwise, if you feel that the NIW could be a more better fit given the way that the assessment is done, which focuses on the future impact of your work rather than the achievements that you have accumulated in the past. So not everyone can still qualify for the EB-2 NIW, and although there can be some overlap in the types of clients who are interested in those EB-1A, O-1 NIWs, it may or may not work for everyone. So let's go into a little bit more detail on the specifics of being eligible. So the first thing to note with regards to the EB-2 NIW is that you have to meet the threshold criteria, which is that you either have an advanced degree, which is defined as a master's degree in your field or higher. You can also qualify with a bachelor's degree if you can show you have more than 5 years of full-time progressive work experience after you obtained your bachelor's degree. And the bachelor's degree and your area of work for the 5 years of work experience need to be closely related, and both your degree and your work experience must relate directly to the proposed endeavor. So you can't be, somebody who has a bachelor's in engineering and then have 5 years of engineering experience and then say that you're going to open a bakery, for example. That would not work. Now, there needs to be that alignment throughout all of your qualifications. Now, if you don't have a master's degree, if you don't have a bachelor's degree, or if you don't have the 5 years of required progressive work experience, and when we say progressive, it's also interesting that if the 5 years of work experience, your job duties stay the exact same, that would actually not be enough to meet the progressive work experience requirement. You do need to be able to show with a employment confirmation letter from your previous employer that what you've been doing, your job duties, your responsibilities tended to increase in complexity and seniority over time. So that's another important nuance to note. But let's say you don't have that. Let's say you don't have the degree or you don't have the work experience. You can try to meet the EB-2 category by showing that you have exceptional ability in the sciences, arts, or business. And you can take a look at the language here, but exceptional ability is much easier to meet than the extraordinary ability standard that we've been talking about in the EB-1A context. So you must show that you can provide at least 3 out of the 7 criteria of evidence, and this can include any degree, 10 years of full-time work experience, a license to practice your profession, evidence that you have a high salary, membership in any professional associations related to your field, and proof that you've been recognized for your achievements and contributions in your field. And this really can be anything. It can be awards, it can be letters, testimonial letters from professional entities, government entities, or peer experts in your field. It can be copies of patents if you're a scientist and if you are someone who develops technologies, if you're an inventor, evidence that people have been citing your work, like if you publish a journal article and 100 people have cited to it, like those kinds of, evidence can be, something that shows recognition for your original contributions. So really there is a bit of a flexibility on what you can use to argue this particular criteria. All in all, it is easier to meet the exceptional ability threshold as compared to extraordinary ability. It is definitely a lower standard, but you do need to show either advanced degree, or bachelor's plus 5 years, or exceptional ability in order to pass that threshold. But important thing to note is that that is not the end of the story. You still need to prove that your work is in the national interest, and we'll go into a little bit more detail about how to prove that. Right, so the other part of a successful EB-2 NIW petition is by showing that you meet the 3 criteria that's promulgated under Matter of Danisar. It's an AAO case from December 2016 that your work is not something that just benefits your immediate employer or client, but it is something that broadly impacts the field and has national importance. You have to also prove that you're well positioned to advance this particular proposed endeavor, and that on balance, you need to prove to the government that it'll be better for the United States to grant you this benefit compared to the ordinary interest of protecting the U.S. labor supply. And the reason why you need to meet all of the 3 criteria for a successful EB-2 NIW case is because the normal way of getting a green card under the EB-2 classification is by having a U.S. job offer, and having a U.S. company sponsor you with a permanent job offer. And then the U.S. company would go through the labor certification process, which is testing the US labor market to see if there's anyone else in the United States who can take your job and who has the minimum qualifications that the job requires. But the NIW is a benefit where you're allowed to self-petition for a green card. You don't need a US job offer. You don't need a US company to sponsor you. And because that is a significant benefit, you need to show that your profile merits that significant benefit. That is why we say it's a waiver. It's a waiver of the normal requirement for having a job offer and having that US company go through that labor certification process. So we do have other webinars that are coming up that only deal with how to qualify for the NIW. And in those kinds of webinars, we talk into a little bit more detail on how to prove that your work has a broad impact in a way, and this can be met in many different ways. It can even be a broad cultural impact. It can be any work that tends to advance the field as a whole. So really the important thing to note is, how do I prove the prospective influence of my work, and how do I tend to show that what you're doing is innovative in a way that not only benefits the immediate clients or employer who's using your work, but it tends to push the envelope for the field more broadly. So that's kind of a nuanced question on how you can convincingly prove that. So definitely, if you're interested in this pathway, sign up for some of the upcoming webinars that are coming up that go into more in depth about that particular area. Okay, so now let's shift gears a little bit and talk broadly about expert opinion letters. Expert opinion letters are a very important part of all of the visa categories that we've been talking about today, including the O-1, EB-1, and NIW. And expert opinion letters are important because it plays the role of synthesizing all of the information that you present in your petition, and it makes it possible for an officer to understand why your work is special. Why is your work distinguished from the majority of other practitioners who are doing the same thing? What makes your work special? And you have to prove that, and you have to convince the government of that in order to get the immigration benefit, and providing that comparative narrative, right? So explaining what is the prevailing approach in the field, then explaining what you have done. And in the case of EB-1 and O-1, petitions, as Katie mentioned in previous slides, it is very important to note that the evidence is past looking. So you need to show that if you've made a significant impact in your field, you've already made that impact. So the expert letters will explain to the government what was the prevailing approach at the time. What did you do that was different from what was commonly done? And why was it so superior? Why was it so special that it really impacted the field? How did it contribute to the advancement of the field? So we're looking at the past and providing that case study really about how your work influenced your field. So let's go and talk a little bit about some specific bullet points that describe considerations for preparing compelling expert opinion letters. So we recommend getting expert letters from key individuals in the industry that have the right expertise to speak to what the letter is trying to prove. So if you're trying to prove that you've made a contribution to the industry in the past, you want to have the letter voiced from somebody who is already known as a leader in the industry, because you don't want to get a letter from someone who's junior than you, or you don't want to get a letter from somebody who's just your peer. If you're trying to prove influence, you want to show that from the voice of someone who's already known as a leader. So typically letter writers would have decades of experience in the field. Typically the letter writers would have played in senior roles in leading organizations in the field, like CEO, COO, in in areas of business, or if you're an artist, um, there will be, many accolades that the letter writer had already experienced in order to, show the government that this person is in fact a leading voice in the field. So commonly we would also attach a full-length CV of the person who's providing the letter with the letter itself to really give that more credibility when USCIS is looking at the letter. Um, who is writing the letter? So background information is definitely important to provide. Um, employers, letters from employers can help, depending on what you're trying to prove, right? So let's say you're trying to prove that you've played a critical role in a distinguished organization, and let's say that distinguished organization was your employer. In that case, you would want to get a letter from someone who's, a senior person at that employer or organization that can provide that first person testimonial on what your role was in that organization and how was that of significant importance to the organization's activities. So really, the lesson here is that for each letter, there needs to be a purpose of why you're getting the letter. Are you trying to prove critical role? Are you trying to prove original contributions? Really, the lesson to take home here is that expert letters, if they're cookie cutter and kind of just a copy paste of, something that sounds good, that only repeats, what the government wants to hear, is things like, this person is extraordinary without getting into the reasons of why what this person did was special. Those kinds of cookie cutter formulaic letters actually don't work, which is why you want to really work with a lawyer who can help you figure out what is the purpose of each letter and tailor the contents and the presentation of the letter to best achieve that purpose, right? Let's say, let's talk about NIW letters. Some of the expert letters that we use tend to focus on describing the prospective impact of what you're trying to do, because that prospective impact that is future looking deals with the first prong of the matter of Danaher test, national importance and substantial merit. And for that, we don't want to look at the past. We want to look at the future, right? So really, you need to tailor the presentation of the letter to the actual eligibility criteria that you're trying to prove. Otherwise, it's just not going to be effective, and it'll be, a highway to a RFE or a denial. So I already mentioned that we want to use, letters from people who are leaders in the industry. Now, how does the individual know you? That is also an important consideration. In most cases, you want to have a mix of independent expert letters from people who haven't worked with you before, but know you through your reputation or your influence in the industry. And those kinds of letters can be helpful because they can be considered more objective, as you don't have a close connection with them, but nevertheless, they know you because of the influence of your work. The other type of letters that can be very helpful are letters that are personal testimonials from collaborations that you've done with that person in the past, such as, the critical role letters that I've been talking about, where the person who is an insider in the association or organization can testify to the actual impact that your work has had. So these people have firsthand knowledge of your work. And those letters are also very important because they are, testimonials, very detailed testimonials on what you have done and why that was impactful. And people who do have deep knowledge about your work can give that first person narrative. So it is very important to include concrete discussion of exactly what you've done and exactly how this is distinguished from what is ordinarily encountered in the field. Specificity is very important. If you use ChatGPT or Claude or other AI tools to just generate a nice sounding letter, you can get a letter, but USCIS can really look through that. And if you don't provide the actual substance that they're looking for, which is concrete detail that only you can provide, is actually not going to work. So definitely the expertise of a lawyer cannot be substituted. Make sure to put your best foot forward by getting the help of a lawyer who can help you in that process. All right, so now let's shift gears and talk a little bit about some strategic considerations relevant to, when you're trying to choose EB-1 versus O-1 versus NIW, which category should I apply for? There are several questions you can ask in that decision. First question, do you want to stay in the United States temporarily or permanently? So as Katie mentioned in the previous slides, the O-1 visa is a non-immigrant visa, which means it is well suited for people whose intent to work in the United States is temporary. So it is important to note that you can continue extending your O-1 visa as long as there is continued work in your field in the United States. So there is really no lifetime limit on how long you can stay on the O-1 visa. But technically, yes, it is a temporary work visa. It is not a green card, and which actually can be advantageous if you're somebody who only spends a little bit of time in the United States, but you have a lot of other activities that you do abroad or in your home country, or if you have strong connections to your home country and you want to spend long stretches of time in your home country. The O-1 visa can be a perfect fit for you because if you go over to a green card, let's say an EB-1A, NIW, those are both green card options. You do have some restrictions on if you want to maintain the green card, right? You need to there is a minimum period that you need to live in the United States, and there is a limit to how long you can stay outside the United States at a time, and there are tax considerations and things like that. So the green card option may not work for all circumstances. If your intent is to live and work in the U.S. permanently and maybe explore citizenship pathways in the future as well, the EB-1A and NIW are green card options that is more conducive to that. Second question, do you have a U.S. employer or agent, or do you want to self-petition? Now, the O-1 visa does require a U.S. employer or U.S. agent to serve as the petitioner to drive forward the application. The foreign national themselves cannot be the petitioner. However, it is important to note that there are ways to work on this, especially if you're an entrepreneur, maybe you want to create a new U.S. entity that you own, right? So ownership of the entity that, files the O-1 visa is not a problem. So you can certainly found a new company in the United States and use that company as the petitioner to drive forward your O-1 petition. That is possible. There are some strategic considerations related to that, of course, and you need to show that this is a bona fide job opportunity. So get in touch with us if that's something that you're interested in doing. We will advise you on what kind of other evidence is helpful to show that this is in fact a bona fide job offer. EB-1A and NIW are both options that allow a foreign national to self-petition. So you yourself can drive forward the petition. There is no requirement for a U.S. petitioner to do that. So that can be an advantage for some people. Family considerations. So for O-1 visas, it is possible for your spouse and children under 21 can join you as O3 dependents. They will apply for an O3 dependent visa and accompany you, and they can go to school while they're here, but they actually cannot work. Work authorization is not available for spouses, which can be a disadvantage for some people. By contrast, for EB-1A and NIW, both are green card options. And if you get a green card through either of these categories, your spouse and children under 21 can also apply for green cards as derivative beneficiaries. And the usual benefits of work and travel authorization is also available to those derivative beneficiaries who also qualify for a green card. So that can be a significant advantage for some people. All right. So some other considerations, strategic considerations when you're considering moving from a non-immigrant visa to a green card. First thing to note, qualifications. So when we look at the EB-1A, especially EB-1A classification in particular, the government looks at EB-1A petitions with a very strict eye because it is the first preference category. You really need to, provide strong support for each of the criteria that you're trying to meet. And also, holistically, the quality of the evidence must be strong enough to convince the government that you are, in fact, somebody who have reached the very top of your field. Especially important to note is that the language of how extraordinary ability is defined is different, especially if you're in the arts. And if you've applied for an O-1B visa and you've been granted the O-1B visa, you only need to show distinction. But for the EB-1A, you need to show that you're one of the small percentage who represent the top of your field and that you have sustained national or international acclaim. So that's definitely can be a high jump. So you want to make sure to have a lawyer review your profile and advise you realistically on whether that profile is ready to move on to the EB-1A stage. Otherwise, you may want to spend a couple more years really building on those evidentiary criteria that where you feel that you're lacking, so that you'll have a much better case for the green card petition. Timing is another consideration. Consider how much time is left on your current underlying visa, because some visas may be harder to extend or subject to more scrutiny once you make steps to file an immigrant petition, which is an I-140. I-140 is the immigrant petition, and that is the relevant petition that you file if you're shooting for an EB-1A or an NIW. So for example, if you're on a TN visa, the TN visa is an example of a visa that is subject to more scrutiny with respect to immigrant intent. Maybe, depending on your circumstances, you may want to renew your TN visa first before taking action to submitting that I-140 or, green card petition. So talk to your lawyer, assess the risks that are there, and you can, plan ahead the most optimal timing to, take those green card steps if you're interested. Family considerations. If you have children who may also need or benefit from the green card, you can consider filing early, well in advance to avoid any issues with a child aging out at 21. There is this thing called the Child Status Protection Act. It is quite complicated. You do need to, you may want to make sure that you talk to a lawyer many years in advance of the child turning 21, to make sure that you don't end up losing that opportunity because of aging out. Okay, so we'll move on to the next slide. The last question that we want to answer here is the question, are extraordinary ability categories available for entrepreneurs? And the answer to this question is a resounding yes. And there are several reasons why this can be a great option for entrepreneurs. The first point is that EB-1A and NIW are classifications that both allow for self-petitioning, meaning that both are possible options for entrepreneurs who frequently don't have a U.S. job offer or a U.S. company that is willing to go through the sponsorship process for them. And if they try to use their own companies, it will also not be possible because that in itself would not qualify them for the perm process. So EB-1 and NIW can be a great option for entrepreneurs. The second thing to note is that with the changes in the NIW adjudicatory standard under the matter of Danizar AO case that is now the standard since 2016, this has made NIW a much friendlier and accessible category for entrepreneurs. However, it is important to note that not all entrepreneurs will qualify for a green card, and the government has been narrowing the channel a little bit on what kinds of entrepreneurs can actually qualify for a green card. For example, now the government uses a much higher standard of economic benefit. If applicants want to use economic benefit as a basis for an NIW argument for national importance, now they require a very high scale or any other type of qualitative benefit that an entrepreneur brings that will benefit the field as a whole rather than just benefit one's own private interests for profit or the profit of one's immediate customers. So definitely it has become a little bit more difficult, and you need to distinguish yourself as an entrepreneur in order to qualify for the green card, but it still remains a viable, and we still have cases being approved. So it is definitely a popular option for entrepreneurs. Finally, for the O-1A, the important note is it is possible to apply for an O-1A visa, even if you don't have, a job offer with an unrelated third-party company, you can create your own U.S. entity in the United States, and that is considered a separate legal entity, and that company can act as a petitioner to sponsor your O-1 visa. Just note that there may be some other documentary evidence that may be required to show that this is actually a bona fide job opportunity in the United States. Okay, so let's see if we have any questions that came in. We're happy to answer any questions. Maybe give or take 15 more seconds to see if any others come in. No questions so far. Well, if you want to reach out to any of us to discuss your case in further detail on a one-on-one consultation, we're very happy to meet with any of you. Please feel free to use the links that we will provide later to set up a consultation if you'd like to discuss your particular case with any of us. Thank you so much, Katie, for sharing your expertise, and thank you everyone for your participation today. Hope to see you at the next webinar.
Thank you.